yɛbɛba hɔ. But Attorney General Domlevo ora. NDC propaganda eyo mo de chen so mbe ye adwuma. Yehwe ora Domlevo ebisa question bi. Domlevo yanko.
Major concern about the ORA is that it is not going to be successful if we keep or maintain the same legal framework and institutional arrangements for fighting corruption. And my major concern about the ORA is that it is not going to be successful if we keep or maintain the same legal framework and institutional arrangements for fighting corruption and corruption-related issues. What am I talking about? As we speak today, or as you and me, we are having this discussion, to establish guilt against someone for financial crimes, the person, it must be proven by prosecution beyond reasonable doubt. And financial crimes or corruption and corruption-related issues are not issues that are very easy to establish beyond reasonable doubt, because the perpetrators of this type of crime are very intelligent and sophisticated persons, and after receiving the process of crime, they are also able to manipulate evidence, even including influencing the investigators and the prosecution, and at times even the judges. So it is not going to be easy. So I think the low-hanging fruit, which are not being plugged, is what my major concerns, are about. One, if we had changed the legal framework, said that for corruption and corruption-related cases of financial crimes, one does not need to prove beyond reasonable doubt. Once it can be established that Daniel is in possession of resources or assets that do not match his known sources of income, then the onus should shift to Daniel to prove to us how he or she got it, if it's a lady. So if we do that reverse burden or lifestyle audit or unexplained wealth, I am sure that alone can deter people who intend even stealing. And of course, those who have stolen, we can easily get them to refund the money to us and maybe punish them.
So we aye owura Demlevo on some penny forecast and say wuntimi unioma wo se wo kashiri ana enye. The basic principle of law when it comes to proving for criminal cases, proving beyond all reasonable doubt. And the reason, the basic principle of law which seeks to protect innocent people is that it will be better, say we save hundreds of criminals na than see one innocent person akoda jail. It's a one innocent person ko jail. That means we've not done justice to that person. So improving criminal matters, unlike improving civil matters, which is probabilities, balance of probabilities. Here you need to prove beyond all reasonable doubt. Domlevo ya aware said that is the basic principle of criminal cases. Nemomuno omuntimi omoniyomenti. Owura Domlevo ese yan shifte the onus, the burden of proof no. You're shifting free the prosecutor. Near fanko the accused. Said ye accusee when we find unfounded allegations, you drag the person to court, you have no fact, you have no evidence against the person, and the person now must come and explain unexplained wealth to the state. There is a reason here okwa could prove even criminal case here. Court no mawudi can establish a prima facie case. Because we don't want you to waste the court's time. There is too much cases as a court in the daily. Now, if we go the way now, Domlevo kana, what then will happen is that Attorney General Biamuso Okatakyie matoka, the car no effect, medan effect, this, that. Adeche no drag me to court. Or drag me to court, only evidence, only way, only fact. Then we will catch a court and say, baby, I'm doing to improve my case. It's mama the accused numum improving why only dying only car. This is a separate matter. That is why Iyoko is there. If you want people to explain a year or more wealth, acquisition of wealth, you can file a complaint to Iyoko. Organize economic and organize a year debe. But when you go to court on the basis that somebody is corrupt, then you cannot shift the simple basic principle of law that he who accuses must prove. This is simple. This is simple. He who accuses must prove. What's the bien shifting the balance? Now the entire moment to me prove your case, you know. Attorney General.
Brother Demulovo, you know, complain about the slowness of the investigation.
He's been consistent with that complaint.
Well, that is for me very disconcerting and very concerning. My senior brother Demulovo, you know, complain about the slowness of the investigation.
He's been consistent with that complaint.
Well, that is for me very disconcerting and very concerning, because their report was just bare bone allegations, right? And I cannot take bare bone allegations to court.
Okay, so when you're in America, if a year already Demlevo say yes, sir, the burden of proof. The only reason Demlevo is calling that the burden of proof should shift to a year the accused instead of the prosecution, you know, and say Demlevo more report, you know, me come Attorney General, no. Some kwase report. Him ake and drone konkonsa and the wumo. And then yamana meka. Attorney General numu asem clean. Yentini view.
Brother Demulovo, you know, complain about the slowness of the investigation.
He's been consistent with that complaint.
Well, that is for me very disconcerting and very concerning, because their report was just bare bone allegations, right? And I cannot take bare bone allegations to court.
Their report were bare bone allegations, and I cannot take bare bone allegations to court. So it is not about shifting the burden of proof. Ora Demlevonim say, and your man or mojiji ye ora, or mo printing ye papers, akasi, or mo say ye papers, or new kuja 22 mirror of justice, or mo wasting your time. Any a yisa kwa ya wine ho a moral judge a Martin Pebu lawyer Martin Pebu. Womu wasting your time no and consan quantum kuchi him insuring bare bone allegations. This is the Attorney General speaking, not me. No Kwame Afrifa Mensah, you may not like me, but clearly I am not the one speaking. Attorney General said the Demlevo mo de ba ye no a sankwas in simhunu manfo na beye what you say him. Paper 10 no mo printing no mo submit your mama no mo deceive your mama enya na meka yenti Attorney General biu.
You know, complain about the slowness of the investigation.
He's been consistent with that complaint.
Well, that is for me very disconcerting and very concerning, because their report was just bare bone allegations, right? And I cannot take bare bone allegations to court.
Ora no insuanim. Okuya trosi ye benya 21 billion ama Ghana. Attorney General say insuani ora nim. Just afi no kohwe na odi insu. But the Attorney General yemusa question. If these are bare bone allegations, why the press conferences? Because the public who deceive you. You, the Attorney General, under Article 88(3), is solely responsible for initiating a year conduct and conducting of prosecutions. But an Attorney General, every citizen in Ghana, Oba no aba be press conference. No jailing Crofono, what me kaka say, a former national security coordinator or a part of the scandal. No one make a pronouncement to the effect that they are thieves. This is thievery. But Attorney General, you know that these are legal conclusory remarks. When a lawyer who is an Attorney General prosecuting a case begins to make pronouncement as though he is the court, before a pronouncement can be made to the effect that somebody is a thief or otherwise, it is only a court of competent jurisdiction that has the jurisdiction and the authority to make such conclusory remarks and pronouncements. Now, when we have an attorney general who has the duty to prove the case in court, that's how attorney general no, or make a conclusory statement like this is thievery, they are thieves, it is worrying. So if over 200 cases of alleged looting exist, the attorney general no, is required to be investigating. But on our also should be any. Now, you're sorry for the attorney general view.
21 billion. About how much do you realistically estimate that you can achieve for the country?
Okay, so let's start with the oral report. The oral report was in segments, and 2,000 and plus cases that you are talking about came out of the various segments. So, for instance, if you take the land, right, you take the land looting cases, they are one component, okay, of the oral cases. Not all of them, I can say this with certainty. Not all of them will end up, going to court, right? There will be some of them. There are some of them. We are, realizing that the evidence, okay, because the oral report was a collection of allegations, a collection of complaints, and that is why I find it a bit disconcerting. When people like my brother, my senior brother Developmental, complain about the slowness of the investigation.
He's been consistent with that complaint.
Well, that.
Attorney General, yes, Attorney General on another thing. Attorney General making remarks, which is very worrying.
We are doing offshore investigations. So I have foreign asset recovery companies, okay, or personnel that are helping me, experts that are helping me to trace assets abroad.
Okay.
Yeah. So we are doing them.
And you do them simultaneously with your investigations?
We are doing them simultaneously. Assess a matter, okay, and have still responsibility, right, for your sector.
That's right.
Right. But when it comes to technical matters such as a construction project, you have technical people working on and advising the minister. So I don't know by what means a minister is going to be able to say that this IPC ought not to be paid because it is false.
Okay, so Attorney General, I make a comment, and this was in reference to the Sh0cking issue. Now, the pronouncement near very worrying. Samseladi Anyani is asking him why or discontinue some of the cases or drop charges against the likes of my very good friend Collins Dada in the Sh0cking issue. Now, Attorney General is talking about a year or dropping cases because only the entire minister must be charged when some of the things, infractions, and here based on technical advice. I'll come and address that. But yes, Attorney General, briefly on this.
Opinion that this ought not to have gone to trial in the first place. There is no point wasting the state's resources in conducting a trial when I know that down the line, all right, the state is going to lose. That will be reckless. That will be professionally, and in fact, it will be unethical on my part to assess a matter, come to the determination that there is reasonable doubt, the evidence doesn't stand up, and then I say, okay, you know what, just so that I satisfy, the public, let this, continue. No Attorney General should be conducting himself or herself in that way.
Now, no Attorney General should conduct himself.
Great. Individuals who are associated with the NDC, do you regret your early decisions involving, nolly prosequi filings and the famous 60% bargains?
No, I don't. And something, you've known me for many years. If I don't believe in something, I wouldn't do it. And when I came into office, I did an objective professional assessment of all the pending cases. And remember, I keep reminding people that I was involved on the other side as defense attorney.
Muntie Adia Attorney General, you could read the Constitution. Muntie Adia Attorney General. Attorney General said he was involved in the other side as a defense prosecution. Okay, so now Attorney General, Yentia de Obabeka, Yenti.
Assessment of all the pending cases. And remember, I keep reminding people that I was involved on the other side as defense attorney, right? If I didn't believe in the innocence of my clients, I would not. In some cases, I would not have, participated in, their as part of their defense team. Okay, so I had an insider view of most of the things that happened. So, for instance, you take, Sh0cking. Okay, Sh0cking, by all standards, was poorly investigated. All right, and the charges were poorly thought through. I'm saying this with all due respect to the people who drafted the charges, to the, state attorneys who were involved. I believe in their professionalism and I respect, their knowledge of criminal law a lot. All right. In fact, some of them are better than I am when it comes to criminal law. But I did an objective assessment. And so I give the Sh0cking case as an example. Now, if you look at the case, they were talking about $200 million, all right, of funds, that were misused or lost to the state as a result of the actions of the persons who were charged, including my then client, Collins Dowda, all right? Well, we did an assessment of it. Collins Dowda was charged with causing financial loss to the tune of $200 million. But Collins Dowda was in the ministry for a very short period. At the time that he was leaving, only $94 million had been expended.
Attorney General said, oh no, because now or insider knowledge, and then the boy money concluded say charges in a week. But the Constitution says something very different and it's very clear. Yanko read Article 284. Not Yan Shadi, Yan read Article 284. Now already Article 284. Article 284 says that a public officer shall not put himself in a position where his personal interest conflict or is likely to conflict with the performance of his office. Tienye, Article 284. I say, where a public officer shall not put himself in a position where his personal interest conflict. So Attorney General no a lawyer ma Collins Dowda, and then because now a lawyer ma Collins Dowda now our insider report and obey Attorney General and we use only 2 years Attorney General and the track case in him on to us. Meanwhile, say a week here, it should have been the court which will say that evidence a yediabano and yet enough. Attorney General using the discretionary powers within the Constitution, under the Constitution. But even in the usage of the discretionary powers, Article 295B, 296B, it talks about the use of discretionary powers. So when you are using discretionary powers, it must not be arbitrary, it must not be capricious, it must not be biased. So using privileged information, you will gain it as a defense lawyer to later drop charges as Attorney General. It creates a perception of bias. So Attorney General now or defense attorney, Emma Collins Dowda. Now and they wababa Attorney General. Or so what drop it charges against Collins Dowda. Or see ni say or Attorney General or fair. But he has forgotten. Says why Attorney General no or dropping cases in one. Although a discretion, so about dropping cases. But it violates the spirit of fairness. It undermines the public confidence. And it places the Attorney General in a position, a constitution, forbade clearly. Was this the Attorney General or a public officer? Now, be you show discretionary powers, it must not be arbitrary, it must not be capricious. Again, you should not put yourself in a place. Now, even if the intentions were pure, and a do Attorney General and I na Sh0cking because of Justice Rimsai, my former constitutional law lecturer who is also a friend, a very good friend, na Sh0cking. But I must say this in the interest of governance. Even if the intentions were pure, now clearly it appears as conflict of interest. if so your attorney general now be catch you say wo now your defense attorney for a client and now be your attorney general into a case anymore. Again, minister no your attorney general make a point to the fact that why is the minister being held liable for technical construction errors, and that they relied on expert and cannot be expected say be detected a false interim payment certificate. Now I don't agree with the attorney general. The constitution disagrees with you because the preamble of the constitution demands probity and accountability. Attorney general, you are aware. The frame may be a vicarious liability, ultimate responsibility. Now, this is a case where Attorney General under Ayi, Yankongo read Article 67, Article 76. Article 76. Article 76 say, the cabinet shall assist the president in determination of general policy of government. The cabinet, the Attorney General, we are part of cabinet. Although you are a minister may not be a technical engineer, but they are custodians of public funds. If it's a minister, no, and they also sign. So they are responsible. So mobile oversight responsibility. Ama every adebia edebromo a jessica free the public in hall. It is an attorney general Bekachere said there were technical errors and infractions, and for that matter, the minister na yedi a public funds and no manano. Or no any oversight responsibility. We cannot hold them into accountable. What kind of logic is this, Attorney General? So Okatakyie said, Collins Dada, no a minister, and on the advice of technical people, it will release his Sikano, and for that matter, he cannot be held a year liable. Ignorance is not a defense. The fact that he did not know said there was error cannot be a defense for him. Ignorance can clearly not be a defense. So Attorney General Beka said it was Attorney General, please respectfully, this your position is a bit worrying. You are becoming more of a media general than Attorney General. Respectfully said, you are becoming more of a media general than Attorney General. Again, Attorney General says it is reckless, unethical, and waste of state resources to pursue a case he believes the state may lose. But justice to me is not a gamble. Attorney General, what the man for court no TNA? It is not just about CIG Sika. That is why I have a problem with a yewo opposition. I want to say, and grofo we are man for the Sika or mobile plea bargain. No more the 70%, 60% bar obeje. It is worrying because one of the fundamental principle of punishment is deterrence. Justice is a duty, and one of the fundamental principle of punishment say you do be a court, you punish nipa no, and yen nipa no be suffer ne nkwanti ani hia ye. They mom say be serve as a deterrence. Nema afoforo kon no so mo be wie sika. Now with the current posture of the Attorney General, where man for wie sika also will negotiate with them for plea bargain and a fire here, eti wura you can say dufo aba wabetua sika ni bi eti me so wonko. Any and sadia minya kwana me ba be public officer, all I have to do is that I say me wie sika ni bebre. Na me wie bebre na oba na ache me a me se plea bargain me tua 70% na macheko. So it is not just about a year or punishing Nipana na year Sika, but the public interest demands a trial, not merely for conviction, but also to establish a record, to expose the wrongdoing, to protect the public purse. That is what we are talking about. If it's a constitution about probity, accountability, social justice, and the account, the only way you can deter people and uphold the sovereign will of the people, which is about exposing a wrongdoing, which is about protecting the public purse. It is about prosecuting the people, just so the others will not have an incentive to get into such matters. So although dropping cases may save money, as you are saying, It may help the exchequer, but it does not help justice. It does not help accountability. It does not help Ghana Attorney General. So please, this analogy is very bad. Your stance is very bad. It's a weak stance. If indeed you want to, medical can say MPP ni bia ria manfonwa monjeli ni pano. And MPP ni bia no eba be supporting kwase asem. Se minya akwanya se meso manfo na me wie na me ria manfo na monjeli me. I must be able to be responsible for my own actions. So the Constitution of Ghana is not just a suggestion. It is not optional. You cannot come and sit here and say that you must prosecute the people. Because the Constitution is the supreme law of Ghana. And when the Attorney General's actions or inactions appear to contradict the Constitution, yen prosecuting Crawford to serve as a deterrent. For me, Ghana deserves better. Ghana deserves a transparent government. Ghana deserves accountability. The Attorney General position way is very wrong. You need to move away from it. You cannot treat this business as usual. Say Attorney General say. Attorney General say. As the same side, please tell your boss. I know that now no call hacker crowd fetch. And I know a call crowd fetch in Nigeria. But in the interest of governance, some of these conversations must be had. With the greatest of respect to the Attorney General, with the greatest of respect to you, Justice Rimsai, I don't seek to undermine the authority of the Attorney General, but I believe that it is worrying. The position that your boss and your institution, your edifice is taking is a bit worrying. It needs to be checked. But the American say it needs to be checked. And the Attorney General, whether we like it or yes, clearly, you need to prosecute these cases. You need to prosecute them. You're moving away from a year Attorney General and Seminona. Let's go and check Bank of Ghana leakage via leaked report from Bank of Ghana, where suggests that Bank of Ghana recapitalization of banks. Recapitalization of banks. Now, recapitalization of banks, you will start the relevant questions. Recapitalization of microfinance institutions. Recapitalization. The questions that needs to be asked, we are going to ask here the very important questions. Bank of Ghana, Yahunu be paying. Mo yes, I deal we. Emma, a year banks in a be weak. A banks in a be weak, And I could forward the na by the Mobete Yebe Kulusi. Obekaya, and be no coma, yes, a man's hotel near this car. Capital Bank near their coffee fast. NDC, your mama and the Maomo. Now, leaked report shows that Bank of Ghana saw a recapitalization of banks. Microfinance institutions. No, because almost say a good for the pencil NDC 4. So we are asking the questions. The issue of Ponzi schemes, Yakai men's good. Yakai a year back on friends say, okay, so this is the report. Now, Bank of Ghana reporter I've sent my people to do a lot of work. They are going to, but we're asking the questions. Men's good DNA been now for the microfinance institutions. Yeah, we start the relevant questions. DKM DNA been now. You start the relevant questions. Now, Bank of Ghana see new reforms and it's just a takeover because almost you microfinance no more MPP for recapitalization. nefa he ne kosi he. What is the real objectives? Ye de ni di akiri. Now is there a way to acquire control over private institutions and ade be ya? Ni nyina ye de ni e di akiri. NDC and they demonize the banking sector. NDC call it reckless. They call it political. It will maba no so mo ye recapitalization. Esi ehwe ni ye de ni di akiri. Won be wie no mo pese say wo movie the baseline capital of a year microfinance. No mo di akosoro. Afi na nkomo no twetwemba. We are going to have the conversation into detail in the coming days. The Bank of Ghana untimi mfa nkoma. You do not need to proceed. Says reforms and be good by microfinance. Where a leaked report from Bank of Ghana. If a big good microfinancer, you cannot proceed. And as a money be scared ya de any dear chiri. We will be in Surubia, money be scared this one, ye de any dear chiri. The kind of the records are there. Let's recap what we did tonight. Tonight we were able to prove that although NDC say omocha John Mama buying also omocha COVID-19 levy mu. Nanso me no kase omugusua eje COVID-19 levy no. Enti Killnet aban. Me no kase gold board ebe ka kire so Bank of Ghana so Ghana boka abno se asare subjected the governor of Bank of Ghana when to me improve it see a boka Akufo-Addo pencil good for reserve. Enti Killnet aban. We were able to prove to you tonight, say between NPP and NDC, the most corrupt political party, NPP, it is NDC. Again, we were able to prove to you tonight that Attorney General Anya so obe fight corruption. Media prosecution yen the chance so obe call into the docket, obe call into a court, no ako face court no the evidence ako. Media prosecutions and the chance are. Aha, for the records, meeting Okatakyie Afrifa Mensa. We keep on bringing you the wo wadwene enko so. Ye bie wani ekọ bia wo wani enko ye. Se be ya Killnet aban ntimi ntum futuro enwani. I came just to serve you and maybe I made the best. Thank you. Bye bye.